Chapter 3. Bona Notabilia. Cases in which probates and administrations are to be granted by the prerogative court. If a man die in one diocese or peculiar jurisdiction, without any goods there, but hath bona notabilia in another diocese, in such case the right to grant administration is in the Archbishop. Nelson S. Abrid. 159. If any person was, at the time of his death, possessed of goods and chattels in some other diocese, or dioceses, or peculiar jurisdiction than in that wherein he died, amounting to the value of 5 litres, at the least, 93d canon. If there be bona notabilia in a diocese under the ordinary jurisdiction of the bishop, and also in a peculiar in that diocese, or in 2 peculiars situated in the same diocese, in such case the probate belongs to the Archbishop. It is expressly so laid down by Gibson, Swinburne, and in a case in Sidofin, and it is declared by those authorities, that in such case probate shall be granted, not by the diocesan, but by the Archbishop, because such peculiars are exempt from the jurisdiction of the diocesan. Sir John Nicol, in Parker v. Templar, 3 Philemorus Reports, 247. If a man have goods of the value of 5 litres in one diocese, and a lease for years of the same value in another diocese, they are bona notabilia, for which the Archbishop shall grant administration. 1 Rolls Abrid, 909. If a man have goods of the value of 5 litres in one diocese, and an obligation of greater value in another diocese, and the obligation shall be there, these shall be bona notabilia for the Archbishop to grant administration. 1 Rolls Abrid, 909. To make bona notabilia, a debt without specialty shall be accounted to be bona notabilia, where the debtor resides. Hill, 37 Illas, but not where the testator lived. 1 Rolls, 909. If a man die intestate, having divers debts and obligations in several dioceses, the debts are called bona notabilia where the obligations are, and not where the debtor or creditor resides. Hill, 37 Illas, Drin, 17 Jazz, Inter Trowbridge and Taylor, per curiam, 3 Dyer, 305, 1 Rolls Abrid, 909. Loddington and Draper, 3 Cap. 433, Daniel v. Lucan, 3 Dyer, 305. If a man have bona notabilia in Ireland and England, and die intestate, there shall be several administrations granted, that is to say, by the Archbishop of Dublin for the whole within his province, and by the Archbishop of Canterbury for the whole within his province. But it is to be understood, that he had bona notabilia in divers dioceses within either province, or goods within the diocese of the Archbishop, for otherwise, the grant ought to be by the ordinary where the goods are, and not by the metropolitan. D. 14 Illas, 305, 1 Rolls Abrid, 908. But if a man had bona notabilia of 100s in divers dioceses, besides that in which he died, the metropolitan shall grant the administration. 10 H. 7, 166, 1 Rolls Abrid, 908. If a man die in one diocese, or in a peculiar jurisdiction exempt from the control of the bishop of the diocese in which it is situated, having goods to the value of 5 litres in any other diocese or peculiar jurisdiction, there must be a prerogative grant. If the intestate leaves goods in several peculiars, the Archbishop of the province hath the right to grant the administration. 2 Lev. 86, Shaw v. Stourton. If one leaves bona notabilia in 2 dioceses of Canterbury, and 2 dioceses of the province of York, there must be 2 prerogative administrations. Burston v. Ridley, 1 Salkeld, 39. Sire Faces, on a judgment in Banco Regis, as administrator of J.S., and in his proffered, shows an administration granted by the Archdeacon of Dorset. The plaintiff having made this administration his title, the court could not admit that to be a title which was in title. Pashk, 1 Nan. Adams v. Turtenance of Savage, 1 Salkeld, 40. J.S. Having died in Dorset, the judgment, at Westminster, would be bona notabilia at Westminster. Vide Keg v. Hurton. 2 Lot. 399. If a man die in one diocese and have a mortgage in fee, or for a term of years, in another diocese, and the deeds shall be in some other diocese than that in which he died, the mortgage shall be bona notabilia, and a prerogative probate or administration shall be granted, to obtain an order for any payment of money out of the Court of Chancery, to the representatives of creditors, where such money is paid into court previous to the deaths of the creditors, and where such creditors die or leave bona notabilia in another diocese, a prerogative probate is indispensable. 7 Versi, J. 409, 12 id. 417. It is not necessary that the deceased should have to the value of 5 litres in each of the several dioceses where his goods are dispersed, but if he had goods to the value of 5 litres in any one diocese besides that in which he died, they should constitute bona notabilia, subject to the superior jurisdictions. 3 Bacon Esabrid. 37, Godolphin, 69. If a man die in Itinia, leaving goods to the value of 5 litres in any other diocese than that in which he had his last usual place of residence, and besides the goods he had on his journey, there shall be a prerogative grant. Cases in which the probates and administrations are not to be granted by the prerogative court. If a man hath goods in one of the provinces in England, and some goods in France, or in the East Indies, then one administration shall serve the turn, because there is no jurisdiction we take notice of. Shaw v. Staunton. Freeman, 102. If a man dieth in France, and hath goods in the diocese of Norwich, and the question was, whether the Bishop of Norwich should grant administration or the Archbishop. North, ch. J. The Bishop of Norwich shall grant administration, unless he hath bona notabilia, and his dying in France is no more than if he had died at Norwich. Cecil v. Darkin. Freeman S. Reports, 256. J. S. Died possessed of goods, valorous 5 litres in the diocese of London, and also in Durham. Lessor of the plaintiff took out administration in Durham, and also in London, the dioceses being in the 2 provinces. Per curiam, the administrations in the one diocese and the other were held good. Michigan. 1 Nan. Burston v. Ridley. 1 Salkeld, 39. Wilson died intestate, at Lincoln, having in his possession there an obligation from one York, who resided in London. Administration was granted at Lincoln. Prohibition prayed to the prerogative court in suit to repeal the administration. Prohibition granted, and per curiam, bona notabilia is where the obligation is. Hillary, 26 Car. 2. Loddington and Draper, 3 Keble 433, 438, and Vidi Daniel v. Lucan, Dyer, 305, and Strobridge and Taylor, Dyer, 305. If a man die in one diocese, having a mortgage, either in fee, or for a term of years, of an estate in another diocese, but having the deeds in his possession in the diocese in which he died, the mortgage being a debt by specialty, shall be assets where the person died, and the probate or administration shall be granted by the bishop or other ordinary of the place where the person died, and not by the prerogative. If a man be occasionally commorant in a house of his own in another diocese, though it is for ever so short a period, and dieth there, not having bona notabilia in that where he was usually resident, probate shall be granted in the diocese where he died, for he cannot then be considered as dying in Itinia. 4 Burns Ickle. Law, 191. 1 Salk. 37. If a man die in Itinia, and have not bona notabilia in any other diocese than in his usual place of residence, the goods he had with him on his journey shall not be bona notabilia, and probate or administration shall be granted in the diocese of his last usual place of residence. 92 D. Canon. If a man die in one diocese and have in his lifetime, and at the time of his decease, goods or chattels less than the sum of 5 litres in any other diocese, or dioceses, or peculiar jurisdiction than in that in which he died, he shall not be deemed to have bona notabilia, and shall not be liable to the prerogative court. 93 D. Canon.